First, we will deal with the factual and legal requirements of progressive realization, focusing on the constraint of available resources and how the state has addressed this problem. And under this topic, we will also deal with the IEJ's arguments on affordability. Secondly, we will deal with Orders 14 to 19, that is the income threshold, the grant value, and the structural interdict, against the background of affordability and progressive realization. And we will also deal here with the IEJ's argument on retrogression. Thirdly, we will deal with the 4 regulations which we defend. That's Regulation 3.2, dealing with online applications. Secondly, the interpretation of income and financial support. Thirdly, Regulation 2.3, bank and database verification. And lastly, Regulation 5.3, the limitation on amounts appropriated. Lastly, we'll briefly make certain submissions on remedy. Justices, we will only deal with the argument on supplementing the record and admissibility of further evidence, should the court so direct. Our position is crisply stated in our heads of argument on that issue. I merely point out that as far as we are concerned, we understand that page 98 of the replying affidavit has finally made its way to the court, and we apologize both to the court and to our learned friends for the inconvenience caused. Let me then immediately commence with available resources and progressive realization. Justices, at the heart of this matter, we submit, is a fundamental divergence of political, economic, and legal theory. On the one hand, there is the laudable desire, which is shared by Treasury, to widen the net of social assistance as much as possible. The divergence is how to achieve that end and which branch of government can or should do so. Treasury has set out in considerable detail that it simply cannot afford to do more, having regard to the multiple demands on the government and the depressed state of the economy. The IEJ says it can do more. All that it has to do, says the IEJ, is to increase taxes or borrow more money. And critically, it says this court should endorse that approach. We will submit that the IEJ's stance is based on a misconception of both the nature and enforcement of socio-economic rights and the separation of powers. The attack on the various regulations and its acceptance by the High Court must be approached in the context of the extraordinary complexities of the competing demands on the state's resources. The High Court dismissed Treasury's concerns in this regard without a proper evaluation of the evidence and without a proper appreciation of the limits of judicial intervention in complex matters of budgeting and the need to balance a multitude of competing claims. Despite numerous cautions by the Constitutional Court, in cases like Subramoni, TAC, and Mazibuko, the High Court weighed in on the national budgeting process, ignoring the warning that courts are not institutionally equipped to decide how public revenue should most effectively be spent or to adjudicate on highly complex issues of social and economic consequence. That caution by our courts is scarcely surprising, given the massive complexity entailed at both a policy and a legislative level when it comes to budgeting and spending priorities. To appreciate just how complex that budgeting process is, we draw the court's attention to Chapter 4, that's sections 26 to 31 of the Public Finance Management Act, and particularly Section 27, subsection 3, which sets out in detail what the budget must comprise, and it prescribes a long list of things which have to be taken into account: estimates of the revenue expected, estimates of current expenditure for the financial year, estimates of interest and debt, estimates of capital expenditure, estimates of revenue excluded in certain categories. The list goes on and on. And it's not only the Public Finance Management Act. It has to be read together with, for example, the Money Bills and Related Matters Act 9 of 2009, which in Section 7, subsection 2, says that in addition to the information stipulated in Section 27 of the Public Finance Management Act, the documentation tabled by the Minister with the National Annual Budget must include, and then another lengthy list of things: proposed fiscal framework, key macroeconomic assumptions, and so on. And that's by no means exhaustive of the statutory framework. There are many other statutes which regulate what goes into the budget, including statutes like the Adjustments Appropriation Act 49 of 2024, the Interprovincial Fiscal Relations Act 97 of 1997. These are deeply complex legal matters. But at the policy level, the evidence from Treasury establishes that there has been a concerted effort to address the problem of poverty. Treasury is acutely conscious of, and I use its words, the extreme levels of poverty faced by too many South Africans. And it has an appreciation which lies, as they put it, at the root of much of its approach to the budget as a whole. I will give you the paragraph numbers in the answering affidavit. They're all in volume 4. That was at paragraph 11. And at paragraph 15 in the answer, Treasury says that South Africa has one of the highest fiscal spending on social protection of any developing or emerging market country in the world. Between 2014 and 2027, South Africa has or will spend between 55.8 and 61.6% of its total budget on what is defined as the social wage, which includes social security and the fulfillment of various other socio-economic rights, such as education, health, and housing. This approach arises, that's at paragraph 15. This approach arises in the context, as Treasury explains, of a dramatically weakened fiscal position of government in the last decade, and more spending, the absence of economic growth, and rising debt. That's at paragraph 17. And as is explained, government can only expend money it extracts through taxation. Borrowing money is nothing more than deferred taxation. That's at paragraph 16. And the demands of the state, again I use the words of Treasury, concern virtually every facet of society, including obligations flowing from the socio-economic rights in the Constitution: access to adequate housing, access to healthcare services, sufficient food and water. The list literally goes on, and all this in circumstances of a relatively small tax base, a problem of tax evasion and non-compliance. That is in paragraph 18.1. Treasury says that further or continued expenditure on the SRD grant, by definition, must come at the expense of some other expenditure. That's in paragraph 37. And contrary to the approach adopted by the High Court, Treasury put up detailed evidence of the state's multifaceted approach to the problem and the plans adopted to address it. And it explained the fiscal constraints under which it operates. The availability of resources is, of course, a critical qualification of the state's obligation to progressively realize the right of appropriate social assistance. Those constraints are set out in considerable detail in Treasury's answering affidavit over nearly 30 pages, under the heading, the Treasury's approach to social assistance, and those are set out in paragraphs 10 to 54. And I cannot obviously do justice to everything contained in those pages in oral argument, but the gist of it is simply this. Treasury's medium to long-term plan is to facilitate and promote economic growth in order to create jobs. This is presently accompanied by huge expenditure on social assistance. And the dilemma facing the state is expressed in the following way in paragraph 24. It is said, "It is unrealistic and counterproductive to commit the state to providing significantly more resources to grants, as opposed to investing more in creating opportunities for people to have sustainable livelihoods. Social assistance, at least in the form of relevance here, is meant to be a stopgap measure while people are enabled to become economically active. The unfortunate truth is that the two problems are inextricably linked. The fewer people who are economically active, the less resources available to the fiscus. And the fewer resources available, the less the state is able to assist the poorest of the poor with social assistance." And in its approach to addressing the problem, Treasury describes a range of policy initiatives and plans, all of which must be taken into account as part of the obligation of progressive realization. That is because, as Treasury explains in paragraph 23, the problem of the inability to support oneself is a function of many factors, the most prominent one being unemployment. To address this, causal factors, which include economic growth, skills building, prioritization of specific groups of people in the provision of employment opportunities, education, training, and others. And pursuant to that approach, and you will see this in paragraph 23 together with its annexures, there have been a number of plans which are already in place. These include the South African Economic Reconstruction and Recovery Plan, the Employment Tax Incentive Act 26 of 2013, the Expanded Public Works Program 2019 to 2024, and the policy entitled Putting South Africa to Work, an integrated approach for the working age unemployed. And in addition, Treasury has commissioned the South African Labour and Development Research Unit, SELDRU, to investigate a range of issues concerning social grants, including the replacement of the SRD grant with a family grant, the introduction of a job seeker allowance, and other related matters. You will see that at paragraph 27. And over and above these initiatives, Treasury refers to others, including the National School Nutrition Program and the provision of free basic services for water and electricity. You will see that in paragraph 51.8. What then is the IEC's answer to affordability? The IEC offers respectfully a beguiling answer. They say that by promulgating regulations that confer legal entitlement to recipients, government must be taken to have determined that it can afford the SRD grant, and thus by implication, affordability is not up for debate. They say that in their heads of argument at paragraph 103. But that argument simply ignores the evidence which establishes in the supplementary affidavit from Treasury that when the 20 Rand increase was mandated, the country's financial position had deteriorated further. The increase meant that the state had to cut other expenditure to give at least some further relief. The increase was the product of a reweighing of priorities, and the way it was put, and this is in the Treasury's further affidavit, which is in volume 9 at paragraph 14, they said that the increase in the grant resulted from a reweighing of priorities, which essentially includes a balancing act. As already explained by National Treasury in its answering affidavit, every time that money is spent on social grants, it compels less expenditure on other budget items. That explanation was entirely ignored by the court below. Apart from this, the IEJ's argument fails at three further levels. First, the question of affordability goes substantially beyond the limited question of the 20 Rand increase. It extends to the wider relief sought by the IEJ, which, if granted, would require additional expenditure between 93 billion and 139 billion Rand. Secondly, the IEJ ignores that the particular SRD grant was expressly time limited in Regulation 5.1 to a specific lifespan. And third, the argument is premised on the notion that the grant can always be made affordable by raising taxes or borrowing. That, we submit, is an artificial and unsustainable notion of affordability.
Right, Mr. Marcus.
Thank you. That lays the foundation, Justices, for what I want to say about Orders 14 to 19, because those are the ones which really are premised on the argument of progressive realization. And we deal with those together because they all flow one from the other. The attack on the value of the grant, the income threshold, is precisely what informs the structural interdict which followed. There is, at the outset, Justices, a material misdirection by the court below, because the learned judge found that the minister had not put up any explanation for the increase of the grant to 370 Rand. That you'll see in the judgment at volume 10 at paragraphs 146 to 148. But that's not correct. The minister had put up an affidavit to explain the increase, and that, we submit, was a clear misdirection. That affidavit is the supplementary affidavit to which I have referred. It's in volume 9 at pages 1635 to 1643. At the heart of the attacks on Regulations 2.5 and 5.1 is the contention that neither the value of the grants nor the threshold value have been progressively realized because, so the argument goes in essence, neither have kept pace with inflation. Hence, the argument is that the value of the grant today is lower than it was in 2020. So at root, the argument advanced is that the retrogression in value is a failure of progressive realization. And on this argument, of course, not only the SRD grant, but indeed all grants would have to be increased in value to keep pace with inflation, or at least run the risk of being in breach of Section 27 of the Constitution. That is one of the central arguments of the IEJ's case. And we would respectfully submit that there are 5 flaws in that argument. This is the argument that, absent keeping pace with inflation, the value of the grant today is less than it was when it was introduced. Therefore, that is retrogression. The first reason is that it ignores the requirement of available resources. Indeed, it eliminates any inquiry into available resources altogether. It says that there is an obligation to increase the value of the grant to keep pace with inflation, irrespective of whether there are resources available to do so. Secondly, we submit that it seriously and impermissibly intrudes into the executive's policy-making functions to determine priorities when it comes to matters of social assistance. Indeed, the argument comes close to usurping that function, and at the same time, it seeks to involve this court's sanction to do so. It seeks to tell the state that what is envisaged, or what was envisaged as a temporary grant, must not only be retained, but must be increased. And that is contrary to the jurisprudence on progressive realization. Grootboom at paragraph 41, Causa at paragraph 48 make clear that the precise contours and content of the measures are primarily matters for the legislature, and a court considering the reasonableness of such measures will not inquire whether other more desirable or favourable measures could have been adopted or whether public money could have been better spent. The third flaw in the argument is that it entails a narrow, a myopic approach to progressive realization, because what it does is, instead of posing the correct question, and that is whether the state has generally complied with its obligation to progressively realize the right of access to appropriate social assistance, it focuses on only one of 8 social grants, and it ignores entirely the range of other measures, which I've already outlined, to alleviate poverty. These are all other measures envisaged by Section 27 of the Constitution. The wording is specific. Progressive realization is achieved by legislative or other measures, and these are all other measures adopted to pursue progressive realization. But even if we are mistaken in that last submission, and it were permissible to look solely at the SRD grant, the argument ignores the fact that there has been progressive realization of the SRD grant in 3 respects. First, the very introduction of the SRD grant in 2020, where none existed before, is itself an instance of progressive realization. Secondly, the change of the eligibility criteria in 2022, when the threshold was changed from 350 Rand to 624 Rand, thereby substantially expanding the pool of beneficiaries, was itself a significant progression. And thirdly, as we know, there was an increase in the value of the grant, albeit a small increase, but that too was a progressive realization. So that's the 4th reason why this argument fails. And then finally, the 5th reason is this. Our learned friends rely for their argument on retrogression mainly on the judgment in the case of Commando versus City of Cape Town. And I'd like to just make a couple of submissions on that case, given the emphasis that our learned friends place on it. The first is that the facts are very far removed from the present case. It concerned the eviction of lawful rent-paying tenants of many years' standing who had resisted forced removals. This was in Cape Town. And it occurred after a private developer had acquired the property and obtained an eviction order in the High Court. And negotiations between the evictees and the city broke down on the question of alternative accommodation. The breaking point was that the city had not built emergency housing in the inner city for 30 years and was thus offering to relocate those evictees to some 15 to 30 kilometers away. So it was this deficient housing program which was declared unconstitutional. So I'll make the simple point that the facts and context are very different. Perhaps more important is this. The IEJ places particular reliance on the judgment of Acting Justice Bilchitz and his approach to the two-element theory of non-retrogression. But the judgment of Acting Justice Bilchitz was a minority concurring judgment by him and one other. They also, in fact, concurred in the majority judgment. The principal judgment does not adopt the same approach as the minority. The majority explains its finding on retrogression in paragraph 103 of that judgment. Let me just read it to you, and then the comparison will become apparent. What they said was this: it is cold comfort that the city does not make provision for temporary emergency housing programs within the inner city. The city should have foreseen in its planning that urban regeneration would lead to displacement. Its conduct was unreasonable because it failed to mitigate the effects and consequences of gentrification on the most vulnerable. It in effect forced the most vulnerable out of the city. This is a retrogressive measure, particularly in the light of South Africa's history. So what one can see from that passage, and that's the only paragraph in which the majority addresses this question, there are three components of the court's reasoning. The first is that the city made no provision at all for emergency accommodation in the inner city. Here, the state has manifestly made provision for social relief from distress in the form of a specific grant, but not only in the form of a specific grant, together with a whole range of other programs to which I have referred. Secondly, the court found that the city ought to have foreseen that the absence would lead to displacement. Here, the state has plainly foreseen the wider effects of poverty and has put in place a range of both legislative and other measures to address the problem. And the third leg of the reasoning was that the city had not taken any steps to mitigate the effects and consequences of gentrification. Here, the state has a variety of plans, legislative and otherwise, to address the problem. So the situation here is simply not comparable. The second element of our learned friends' argument is this. They adopt the argument that, or they ignore the argument in their approach to retrogression, that the SRD grant was intended to be only temporary. That is a fact repeated throughout the answering affidavit. And the finding of retrogression and the consequent orders, those are 14 to 19, rest on the wrong factual premise that the grant is permanent and thus falls to be treated like all other grants. And that brings me to the IEJ's equality argument. A constant theme of the IEJ's argument is that all social grants are conceptually the same and thus must be treated the same. On this argument, since the other grants have been increased, and that is factually correct, but not the SRD grant, this amounts to a form of unconstitutional differentiation. That argument, we respectfully submit, fails for three reasons. The first is the central premise of the argument that all grants are the same. That is incorrect. Obviously, if the premise fails, the argument fails. But the SRD grant was introduced as a temporary measure under the Disaster Management Act, which by definition was intended to have a limited life only. Under the Disaster Management Act, there are specific periods for which disasters can be declared, and measures taken pursuant to disaster have the lifespan of the disaster alone. The current regulations stipulate that their currency is limited in Regulation 5.1, and that is consistent with the Minister's evidence. The second point is that SRD grants are legislatively treated differently from the other grants. The Act in Section 1 defines social grant and social relief from distress separately. The definition of social grant does not include social relief from distress, and whereas the social grants as defined are prescribed in sections 6 to 12 of the Act, social relief from distress is regulated by Section 13, which leaves it to the Minister to prescribe by regulation. So social relief from distress is treated differently from the other grants, and in accordance with the general principles, a change in wording is to be regarded as prima facie a change in intention. Many cases say that, but let me give you the case of R versus Sisilani, which is 1959, volume 2 of the South African Law Reports, page 448, Appellate Division at 453F. And thirdly, at the level of fact, Treasury explains precisely why there are conceptual differences between the different kinds of grants. They say in their answering affidavit in volume 4 at paragraph 95 the following: "It is perfectly reasonable to take the view that inflationary increases, to the extent affordable at all, should be prioritized for grants which are expressly permanent and which have been in existence for decades, and which are by definition the only means of support the recipient will ever receive. In other words, since a child cannot by definition work, he or she is entirely dependent on a child support grant to survive, of course assuming that he or she is not adequately supported by a parent or guardian with sufficient means. By the same token, a pensioner cannot be expected to find work as an alternative to receiving an old age grant. The recipient of the SRD grants are by definition of working age." So that is our argument on progressive realization orders 14 to 19. Let me then turn to the regulations, and I want to say something by way of introduction to the regulations. And it's an important stepping stone to the argument that we advance. It's that the right to social security in the Constitution has an internal limitation. It is only available if a person is unable to support themselves or their dependents. That is a definitional limitation of the right in Section 27 itself. This means that the very terms of the right necessarily postulates an inquiry into whether the affected person is unable to support themselves or their dependents. And several of the regulations under attack are intended to achieve that fundamental purpose. It is also echoed, by the way, in Regulation 2.1, which stipulates that eligibility is limited to persons, and I quote, "with insufficient means as defined." And of course, I'll get to the debate around that in a moment. The IEJ rightly accepts the need for safeguards against abuses. And that is an important concession on their behalf, because the regulations with which we are concerned, database verification, online applications, etc., are all in one or other way designed as mechanisms to curb abuse. But the state's concession, not the state's, the IEJ's concession that safeguards are necessary is an important one, because the yardstick of reasonableness vests the state with a range of options, and provided the means chosen fall within that range, there is no scope for judicial interference. And that is why the Constitutional Court, for example, in Mazibuko, the water case, accepted that means testing was a reasonable measure, for otherwise it would deprive government, this is their words, of a key methodology for ensuring that government services target those most in need. The court further held in Mazibuko that although means testing may not be perfect because it is under-inclusive, this fact must, and I quote, "yield to the indisputably laudable purpose served by means testing. It seeks to ensure that those most in need benefit from government services." That's all at paragraph 101 of Mazibuko, and that we submit is at least the conceptual answer to much of our learned friends' argument. It is not in dispute that in any reasonable system, anywhere in the world, in which public money is used to provide benefits to members of the population, procedural safeguards are adopted to ensure that only those to whom a particular benefit is due may receive it. That is said in answer, Volume 4, paragraph 76.1, and it is not disputed even in reply in Volume 9, paragraph 223.7. That, of course, is respectfully basic common sense, and it serves to prevent fraud, and it ensures that the budget is used properly. That is how it was put in answer at paragraph 76.2. And then comes the issue which is simply a fact of life. As Treasury puts it at paragraph 77.8 of their answer, it is close to impossible to adopt procedures which are capable, without any exceptions and errors, of ensuring that every deserving recipient of public funds receives them and every legitimate claim is weeded out. That is simply absolutely impossible, particularly in a scheme of this magnitude, and that is why, as Treasury puts it in the same paragraph, some compromises have to be made. With that preface in mind, let me turn to the four regulations which we defend, and let me hasten to add, my learned friend for social development will elaborate on some of these, and I will be relatively brief.
Mr. Marcus,
Yes.
before you move off this point, let us just deal with what constitutes insufficient means in terms of
2.1 of the regulations.
Yes. That was going to be the second one I deal with,
okay.
but can I just get rid of online applications first? It will take me a minute, Justice, and I'll get to that very shortly. The attack, this goes to Order 1, and this is the use or the prescription that applications must be made by means of an online platform. And the legal question is really a straightforward one. It is this: is the requirement of online applications reasonable inasmuch as it is a measure which is designed to minimize fraud and wastage and to ensure that eligibility criteria are met and which promotes efficiency? That is the justification advanced for it. We recognize, as we must, that it is one of those areas in which compromises have to be made because no system is perfect. The IEJ says, well, that's not good enough. But recall that the reasonableness component of progressive realization does not inquire whether other more desirable or favorable measures could have been adopted. In other words, imperfect as it is, the court will have to reach the conclusion that notwithstanding those imperfections, it crosses the threshold of unreasonableness. So,
people without the means to even buy a cell phone. There are many people that is not able to use electronic platforms. Why can't they go to the SASSA offices and be assisted there?
it's a fair point. I can't readily say to you any more than I have already said in that regard. Other than this, my learned friend for social development will elaborate on that, because my understanding is, I don't want to intrude on his argument, is that social development has taken steps at those offices to assist with the facilitation of applications, but still by means of online platforms. Yes.
People at their offices online.
My understanding is that that is one of the processes which are in place, but may I leave that to my learned friend to address.
That is the kiosks that are in those specific offices, and that is online as well.
Correct. Shall I make one other point? We do and it's an argument which I appreciate has got its limitations. It's the point that flows from the case of Van Heerden versus the Minister of Justice. It's the Constitutional Court decision. We do refer to it in our heads, which makes the simple proposition that legislation must be assessed by way of the majority of cases to which it applies. Now, that was a case which involved an affirmative measure adopted by the first Parliament after 1994 to provide pensions for those who, by virtue of race, had been excluded from ever being parliamentarians before. And approximately 10% of the eligible recipients of this measure were what were referred to in the papers as the jammergevalle. They fell through the cracks. And the question was whether that 10% was of a sufficient magnitude as to invalidate the scheme as a whole. The Constitutional Court said it didn't, because legislation is directed to the majority of cases. Not every single case, but the majority of cases to which it applies. But Justice Mayer, your point is taken, and the question will ultimately be whether a combination of applications on the electronic platform and using an electronic platform, albeit at the kiosks, at SASA offices, suffices or not. If it doesn't, our argument will fail.
My concern is
That I understand the premise on which legislation allowed for online applications because it was the COVID period. So clearly there was no contact in that period. But having come out of the COVID period, what has been done to now supplement and amend legislation to also cater for those, as has been put by my brother, those who don't have the facilities or the means?
My understanding, you pose the question, what has been done? My understanding is that what has been done is that kiosks for that purpose are being made available. In what number, to what extent, I can't answer. Perhaps my learned friend could do so.
Somebody that can assist people who is not able to work electronic platforms.
And I cannot dispute the logic of what you're putting to me. I can only say to you that the magnitude of the issue is so huge that inevitably, as the Treasury puts it, compromises do have to be made. The question is, how can those exceptional cases, I think that's the proper way to put it, how does one address those exceptional cases? Can I then get to Justice Hughes's question, that is the meaning of income and financial support. You will know that the High Court adopted the argument advanced again by our learned friends before you, that you have to read those terms as including two components, as including the requirement of regularity and the requirement of obligation. We do not need to debate in this court the process of interpretation, which is well known. But let me start with text, because that has frequently been said to be the interpretive starting point. There is simply no warrant for reading into those requirements, into those definitions, the requirements of regularity and obligation. The high watermark of the IEJ's argument on text is to refer to an internet definition given in the Merriam-Webster dictionary, but without quoting that definition. In the High Court, they referred to other definitions from other dictionaries, but none of them supported their arguments. And even a consideration of the Merriam-Webster definition shows that regularity and obligation are not inevitable. Thus, as a noun, it is defined in the Merriam-Webster dictionary as, and I quote, a gain or recurrent benefit, usually measured in money, that derives from capital or labor, also the amount of such gain received in a period of time. But for purposes of our argument, we can accept that depending on context, the word could include but is not confined to regular and obligatory payments. The real question is whether its meaning in a context, whether it carries that meaning in a context where a grant is payable only to those who cannot sustain themselves. That was my introductory argument. The unmistakable purpose is to limit payments to those who cannot support themselves. So the inquiry must be whether they are in receipt of any money, regular or otherwise, obligatory or otherwise, to support themselves. So there's a real sense in our submission in which the wrong question is posed by our learned friends. The question is not whether income includes regular and obligatory payments. It plainly does, and we accept that. The real question is whether income excludes ad hoc receipt of money or donations or the like, and we submit it plainly does not. And that's really the essence of our argument. It's a textual and a purposive interpretation, bearing in mind that the right and the regulations themselves have an inbuilt limitation. And we submit, therefore, that the High Court was mistaken in adopting that argument. Then there is the use of bank and database verification.
So, Mr. Marcus,
Yes.
in respect of the income, that would include donations.
Nations.
Yes.
So the reliance would be, well, in my view, would be on a declaration from the applicant themselves saying that X amount in my bank account is a donation.
Yes, what's held by me on behalf of somebody else. It's not for my use. And certainly, Justice Hughes, the way you put it would be one way of an applicant saying, look, this is not my money, or it's not for my use, or whatever the case may be. And bear in mind, this is a month-to-month thing.
I was just getting
yes,
to that.
Yes.
So,
In a month, I hold money on behalf of X. And in that month, the way I read the papers is that in that month, if I have over the threshold in my bank account, I do not get the grant. Right? So just let me finish my... So that I don't get the grant for that month. Then I lodge the appeal. But for that month, I do not have the finance that the grant was supposed to distribute to me. And I only get it after the appeal stage, having submitted that no, the money belongs to X.
Yes. Once again, Justice Hughes, I cannot exclude that possibility. You might criticize it as an imperfection in the system, but you're dealing with multi-million numbers in applications. There needs to be some form of administrative efficiency. Otherwise, the system will collapse. There has to be some mechanism which deals with the majority of cases to which these applications apply. But if you're putting to me that there can be exceptional cases, I cannot disagree with that.
By allowing evidence on internal appeals.
Yes. My learned friend will address that. You will know that the Treasury's attitude in that regard is we did not oppose that particular matter. So I'll leave that to my learned friend. My learned, I know, again, I'm not foreshadowing his argument, but I do know that his argument extends to demonstrating, if he can, that the High Court misunderstood the scope of the appeal. But the answer to your question, Justice Mayor, is yes.
So if I understand your submission, Mr. Marcus, you accept that there may be exceptional cases where bank verification and other, obviously the money would show it's not coming from UIF, the other databases would show, but if you get money that belongs to someone else, if a proper appeal process were in place, it would result in a delayed payment of the grant, not a total exclusion.
As a matter of logic, I have to accept. Can I?
And again, you would say it's still a reasonable measure.
Yes.
Is that?
I want to make that very point, if I may.
Yes.
It's on the use of bank and database verification. You've got to appreciate in our submission that the IEJ's objection is not a principled objection. If you have a look at what they say in their heads of argument at paragraph 56, they say the respondents do not oppose it, that's database verification, in principle, but only its implementation in light of the high degree of inaccuracy and levels of errors confirmed by the appellant. So it's not a principled objection, it's a question of how it's implemented. But of course, in an attack on the constitutional validity of a regulation or a law, the fact that a particular provision might be abused is not a ground which goes to unconstitutionality. In our heads, I think we quote the case of Van Rooyen versus the state. I'll just check. But that's the case. Let me just give you the reference. It's 2002, volume 5 of the South African Law Reports, page 246, Constitutional Court at paragraph 37, where the point was made that any power vested in a functionary by the law, or indeed the Constitution itself, is capable of being abused. That possibility has no bearing on the constitutionality of the law concerned. The exercise of the power is subject to constitutional control, and should the power be abused, the remedy lies there and not in invalidating the empowering statute. There's a second argument which I should allude to, which is advanced by our learned friends. What they say, and I quote from their heads at paragraph 61, they say that the department, and I quote, do not have to employ bank verification. They could instead deploy methods used for other means-tested social grants, including self-declarations requiring documentary evidence of income and financial support and random checks. That's their argument. But that's respectfully simply question begging. The question is not, and I've stressed this before, it is not whether other methods could be employed. It is whether the chosen method is constitutionally objectionable. And I once again refer in that regard to Grootboom at paragraph 41 and Causa at paragraph 48, where it is stated that that is not a matter for the court to determine. That is, whether or not other desirable or more favorable measures could have been chosen.
Yes, because that will be moving into the realm of the executive.
Exactly, exactly. That brings me lastly to the enigmatic, I do say enigmatic, Regulation 53A, and that's the limitation that payments are limited to the amount appropriated in the attack on in this case, to the amount appropriated to the 2024/2025 financial year to the vote of social development for social relief from distress. What our learned friends contend is that this limitation is irrational or arbitrary, because if the money runs out, parties who would otherwise be eligible would not receive their grant. Now, they're absolutely correct as a matter of logic that that is indeed the outcome. But that is not an outcome that is irrational or arbitrary. It is the logical conclusion of what would occur if the money did run out. In a sense, the qualification that is expressly built into this regulation is an implied qualification in relation to almost any grant. It is subject to, if money runs out, let me put it bluntly, if money runs out and grants which have been promised can't be paid, then the state faces what is probably known as a fiscal crisis. But it's a logical conclusion. It's not desirable, it's not a happy state of affairs, but it's the logic of what happens if money runs out.
Relief grant is annually approved by the amount of it, and whether or not there will be one is annually approved by Parliament.
There is
that if one takes your argument to its logical conclusion, if you have got 500 persons in the queue and the money runs out on the 300, when it reaches 300, then the other 200 then is just hard luck for them. They must go away.
That's the logical argument. I can't dispute that is indeed what would happen. But my principal argument doesn't go to the question of rationality or anything. The principal argument is that it's highly speculative. It's something that's never happened, because the budget has historically never been exceeded, and no person has ever been turned away because the budget has run out. And that explanation is furnished in the answering affidavit at paragraph 53. I do want to just draw the court's attention to one.
Means, in other words, the respondents and the applicants would have been then duty bound to produce evidence to the effect that there were these 500 eligible persons. Correct. And only 300 got.
Correct. It's never happened. It's never happened. So it is hypothetical in that sense. If you're going to ask me, could this never, ever happen? I can't say that it will never, ever happen. But it has never happened, and it is therefore highly speculative. And it is really not the sort of issue which this court should pronounce upon.
Mr. Marcus, might it be challengeable if it did happen?
Absolutely.
But
Absolutely.
your point is it hasn't yet.
It's never happened. Yeah. I want to draw attention.
Sorry, Mr. Marcus, on that, as I understand the broad arch of the respondent's case, it hasn't happened because of the obstacles that are put in place.
Well, that,
and sorry, just bear with me a little bit. And their argument starts further back. They start from the premise that that government has undertaken, it's accepted an obligation to pay this grant to employment age persons who are unemployed and unable to assist themselves, support themselves rather, and that the state accepts that I think it's 18.3 million people fall in that category, and therefore it's failing in its obligation by even setting a budget too low, coupled with putting obstacles in place to make sure that it remains in budget, the dispensing of the grant remains in budget. I'd like your comment on that premise.
Yes.
Obviously, you don't address it directly, but you address it in the way in which you've structured your argument. But
Yes.
the premise that the state has accepted, one, that there are 18.3 million. It's accepted an obligation to provide a grant for those, well, it's a social assistance for those people, and by setting the budget too low, and then by putting the measures in place, that as a whole constitutes an unconstitutional regression, really, of their failure to comply with their own obligation.
Yes.
That's what I understand their thesis to rely on.
That is indeed certainly their thesis, or part of their thesis. A number of comments, Justice Keatley. The first is, bear in mind, I'm dealing with an attack on a specific regulation.
No, I understand that.
Okay.
I do understand, and I just took this as an opportune moment.
No, fair enough. Then I understand the...
I mean, the thread comes through to all of the and particularly to this one.
Yes.
Because, you know, they would say, you've given an obligation in all of your policies, year on year, you've made this obligation. You've underfunded, and now you say that once it's gone, it's gone. And that can't be. You are reneging on a constitutional
Yes.
obligation.
That would precipitate a constitutional crisis were it to come about. I've got no doubt about that. I'm simply saying that in the context of this particular attack, it's never happened and it's hypothetical. But at the level of your broader,
on the premise.
question, it's difficult to separate out those attacks from their threshold attack and their grant value attack. I'm at the moment dealing purely with the attacks on the individual regulations,
Okay.
which have to be assessed according to established principles. But Justice Keatley, yes, you are correct. That is part of their broader argument. We, of course, dispute many of the factual premises underlying that argument, but since I'm dealing with the attack on the regulations, the springboard for our answer to those attacks is the realization that there is an inbuilt limitation, that there have to be measures put in place which determine who is eligible and who is not eligible, because that is the only feasible method to deal with budgeted money. I accept the proposition that they accuse the state of bad faith. They accuse the state of a mala fide scheme to exclude recipients. We do not accept that proposition. We say that such restrictions as are placed in the regulations with which I am dealing at the moment are perfectly legitimate and reasonable measures designed to ensure that only those who are entitled to receive the SRD grant do in fact receive it.
Is the SRD grant the only one which requires Treasury approval, concurrence rather, or do they all? Is that a standard? All of them do?
All of them do,
Okay.
yes. The legislative difference is the one I pointed
Yes.
to.
I just
Yes.
wondered if
No,
that...
No,
yeah, okay.
my understanding is that it's all. I wanted to just draw the court's attention to one thing, and I need to stress that I'm not making a point of it, but it's something that the court needs to bear in mind. There is I'll put it in quotation marks, a mootness issue in relation to Regulation 5.3a, for the simple reason that it has been replaced, as the court knows, by a new regulation, or two new regulations, which change the financial year, which governs the grant in question. So I'm not suggesting that for that reason the court should decline to pronounce upon it. because it's going to be a recurring problem, but I suppose it's merely a technical issue. Maybe my learned friend will have some ideas about it. It will go to the underlying reasoning. If our learned friend's argument is to succeed, I don't suggest that merely because the regulation has been replaced to cater for subsequent financial years that this court should avoid it. That is not my argument. It's a technical issue relating to the order that this court might make or that this court might confirm. Justices, I want to just I'll be very brief on remedy, because it's one of those situations where everything depends on what the court decides. But we stand by the argument we've advanced in our heads, and especially the suggestion that if the broad attack on threshold value and value of the grant coupled with the structural interdict were to succeed, the suggestion that we be given 4 months in which to remedy that is really utterly insufficient. The court knows more than enough to appreciate the complexity of the issue, and what is suggested by the High Court is really a wholesale reconsideration of fundamentals underpinning the social grant system. There is one aspect of that order which we respectfully submit simply cannot stand. And in that regard, it's the prescriptive nature of the order. We have referred in our heads of arguments to the Minister of Environmental Affairs versus the Trustees Groundwork Trust, the decision of this court. It's in our heads of argument at paragraph 77, and it's footnote 118. That was another instance in which this court rejected an attempt to box in the discretionary nature of a particular matter in that case, but the same principle applies here. The order of the High Court is extraordinarily prescriptive, and bear in mind, if that order is to stand, there will be questions of compliance thereafter, and not simply questions of compliance. There will be potentially questions of contempt. That is simply an impermissible constraining attempt to constrain how a very, very complex discretion should be exercised. There's one other case which is similar, to which I'd like to refer you. It's not in our heads, but it makes a similar point. It's the case of ETV Pty Limited versus the Minister of Communications and Digital Technologies. It's 2023, volume 3 of the South African Law Reports, page 1, Constitutional Court, and it's at paragraph 89. And it was a similar situation in which the High Court had been very prescriptive in how, in sending a matter back to the High Court, in sending a matter back to the decision maker, a particular decision had to be taken. And the court there made the point that the broader relief would invariably require this court to dictate to the minister that certain nuanced and specific steps must be taken. What the applicants are in effect asking of this court is to prescribe the procedure that the minister must follow before determining, in that case it was the analog switch-off date. And the court said this was really akin to an order of substitution. So it merely reinforces the point that we have made. In relation to everything else, as I say, almost everything depends on what the court does. If, for example, the court were to strike down Regulation 5.3, the one which limits it to what is contained in the budget, that's something that can be fixed relatively quickly. If it strikes down other regulations, depending on which ones they are, far more time would have to be required.
I know that in for 24 months.
Yes.
But in the...
That would be for the plan, Justice Benson.
Yes. Okay, the reason why I'm raising that, you did allude to the fact that the SRD grants, were conceived to be of a temporary nature and have now been extended to 30th of March 2027.
Yes.
And then what would be the effect if we are with you of an order giving you 24 months to address that? What happens if, come the 31st of March 2027, and social development says we've now reached the end of the road?
Justice Benson, that would be a practical matter. And I would suggest that in that eventuality, it might be for the parties to come back to court and seek a variation of the order. But we should assume in favour of the IEJ that that scenario won't happen. I can't say as a fact that it won't. And we should make an order which is appropriate in the circumstances. That's the best I can suggest. Justice Hughes, those are my submissions.
Oh, those are the submissions. Are there any questions?
It's tea time.
Yes, I know that. Well, thank you. You've actually hit the nail on the head because it's now time for us to go to tea. So we will take the short tea adjournment and we'll resume at 15:15.
Can I assume that I'm done so that I can swap places?
Yes, I was just coming to that. Mr. Eden, we'll hear from you after the tea adjournment. Court will rise.
So look, there's only one here. So we can do this one.
So then I'll put mine in front of the slide.
Yeah, yours also is right. No, all three of ours.
Yeah, mine is there. So then I'll put, I think between here, maybe
Should actually put slightly more central.
more towards her. You don't think she'll say too much? But I'm thinking I can then pick them both up.
Who has a, well, that's the sad thing about you. You know, if you can clip it in the center there, then you have like between those two people.
I can't put it there. Okay. Yeah. Okay. But it's fine, yeah.
Yes, Mr. Eden. But Eden, you've got the floor. Thank you.
First, we briefly explain why a fully automated online-only system for COVID-19 social relief of distress, SRD, is used. Then we turn to the specific orders the Court made to explain why the appeal should be upheld, to enable first and second appellants to retain the automated online-only system as it appears from the regulations. The SRD is dealt with in our main heads of argument in paragraphs 3 to 15. The fully automated online verification process is repeated monthly in the respect of 15 million applicants. You will find that reference in volume 6, page 1096, paragraphs 117, 118 and 125. The monthly verification draws a bright line between SRD and social grants, the latter being verified once upon it being approved by officials. As appears from the regulations, SRD is temporary relief, for the moment 12 months. But SRD is also temporary in that it is awarded only for a month at a time. Beneficiaries of SRD must qualify every month to receive payment, so a speedy verification process is required monthly before the beneficiaries can be paid. At the moment, approximately 8 million people. Depending on variables such as monthly income received into a bank account, a beneficiary may not qualify every month, a fact that was overlooked in the many supporting affidavits attached to the founding affidavit. I've referred to one instance, volume 3, page 553, paragraph 4. The fully online system is, in the words of the answering affidavit, the method that has proven to be the most successful. That is volume 6, page 1082, paragraphs 63, 70, 79, 90, 246.3, 261.2, and page 1192, paragraph 71. The first and second appellants are proud of what they have achieved with this specific rollout. There are 3 critical stages in the fully automated system. That is the application stage, the verification stage, and the appeal stage. The safeguards and methodology employed in these 3 stages result in a reasonable and a rational online-only system. We explain these safeguards of each of the 3 stages when we deal with the specific orders made by the court de quo. The court orders requiring deviations from the automated online-only process impermissibly remove government's entitlement to retain these reasonable measures to meet its obligations. I now turn to the orders. Orders 1 and 2 are addressed in our main heads in paragraphs 16 to 36. These orders of the court de quo declared Regulation 3(2) unconstitutional and invalid to the extent that it allows for SRD applications to be lodged on an electronic platform only. The order requires DSD and SASSA to allow applicants to be processed in person. In the main heads, paragraph 16 to 36, and we explain why that would be a regression.
Could you repeat those paragraphs again, please? The paragraphs. Could you repeat the numbers? That's all I'm asking.
Paragraph 16 to 36 of the main heads, and then 37 to 52 deal with the regression of importing manual human input.
So 16 to 36.
And then 37.
Yeah, it's 37 to 52. When the COVID-19 social relief of distress was introduced in 2020, during the hard lockdown period, no human intervention was possible. But since then, the system has developed substantially. The whole process remains online only, but important safeguards have been introduced and improved over time. At the application stage, the following safeguards are of relevance. The rollout of self-help kiosks has been successfully completed, leaving SASSA offices countrywide with self-help kiosks within its offices where applicants can access devices and internet connectivity. Here, communities are assisted with SRD applications. The reference to that, volume 6, page 1087, paragraph 82. Second, the free of charge call centers referenced in page 1190, paragraph 66, continue to provide for human intervention in the application process. There's a free of charge call center, and they continue to provide for human intervention in the application process. Thousands of queries are dealt with weekly. The reference is volume 7, page 1215. So although the system remains strictly online, Human assistance is provided to those applicants struggling with the online-only process. In addition, and in the third place, there's also an email option that people make use of. That is page 1190, paragraph 67. Finally, SASSA attends forums where information is shared. These forums are attended by civic organizations, including Pay the Grants. That is volume 6, page 1188, paragraph 60 and further. We submit, Justices, that struggling applicants for SRD are therefore not left behind because of the safety net that has been created post the hard lockdown period.
When we deal with these
Safeguards that have been put in place, and this was after the lockdown period, I would presume, isn't it? Because now the kiosks are at the SASSA offices, and there's also this call center. Has the DSD considered having walk-in options for those who are not literate who are not computer literate, I should say? Walk-in options to the SASSA offices and dealing in person with a consultant, just like Home Affairs and the other grant offices. Has that been a consideration? Because that seems to be the concern of the respondents.
Just bear with me. When individuals attend at the SASSA offices, they are directed to the self-help kiosks. So at what level there will be personal assistance there, it's not clear from the papers.
Are we asking the question?
But one would assume that when you have this system of safeguards, that there will be interaction between people at the offices. How else will it be?
But isn't that the kind of detail that should have been in the answering affidavit?
I beg your ladyship.
Isn't that the kind of detail that should have been? The court should have been given those facts. The answering affidavit says a lot about how proud it is of the efficiency, but I struggled to find facts that deal with how the system works. There wasn't really an explanation about the kiosks. And that, that was for that DSD thinks it's efficient isn't really the issue. We need to know, as a matter of fact, what is on the ground.
Justice Keatley, those affidavits were deposed to almost 3 years ago when the self-help kiosk was in a pilot phase. So there are continuous efforts to improve on the system.
And you're saying that from the bar?
No, I'm not saying that from the bar. I'll give you the reference in a moment. But
sorry, I understand that was stated in the answering affidavit.
Yes. Please keep in mind, there are 15 million people on the system. So that the deponents to the affidavits say is the best social system that they have. So we submit that online system brings huge benefits for the beneficiaries.
But what isn't explained, or what isn't answered in the answering affidavit, is what about those who might be blind, impoverished, and in a rural area, for example, who don't have a cell phone? Or, that just isn't, we're not told why it wouldn't be possible or is it reasonable to have an alternate system that would expand the pool? Not to go offline completely. It can retain its efficiency.
Yes, that is what happens when the self-help kiosks are used. It remains online only, but there's assistance to get what the problems were that were raised relating to devices and to internet connectivity.
But you
see, that's the concern that the respondents have raised, and it would be excellent if the DSD could explain to the court that even, I gather from the heads that you are moving towards some sort of a hybrid system, but the hybrid system still seems to concentrate on online applications, because even the kiosk itself is an online
application.
It is a full online system, and there is not a hybrid where people can access the SRD in another manner. They are assisted when they struggle with the application procedure, and I've dealt with the safeguards, the 4 safeguards, the community outreaches. There are forums where people come together, they discuss problems, but the online system is what is allowing DSD to reach 15 million people on a monthly basis. The human resources in DSD and SASSA can never replicate 15 million people.
I think
I want to make sure that I understand the thrust of your submission, that applications are submitted online, but in relation to those applicants who are either unsophisticated, illiterate, computer illiterate, who choose to go to a SASSA office to submit their application on the kiosk available there, would be assisted by a consultant to submit the application online.
Yes, that is correct.
where do we find that, Mr. Fanyati? Where do we find that? Or are you going to give us the refs?
Volume 6, page 1087, paragraph 82. With the court's leave, it's just a short paragraph. Let me read it.
Excuse me?
The page? Can you give us the page again, please?
Volume 6, page 1087, paragraph 82. It's just a short paragraph. Let me read it. SASSA has, within its available resources, implemented community outreaches where communities are assisted with SRD applications. SASSA is currently piloting the use of self-help kiosks within its offices. Depending on beneficiary usage, the self-help kiosks may be rolled out in key strategic areas outside of SASSA offices.
So it's
Piloting, or is
No,
it?
this is what I said 3 years ago.
Oh, okay.
And we understand that has continued and it
But it
successfully
still doesn't
implemented.
say that they are helped in person, which was what my brother was asking you. And it simply says in our available resources. Is there anywhere in the affidavit that says that SASSA cannot, on its budget, make human beings available to read an application and enter that onto an online system? Let the online system work, so the verifications be done online, subject to whether we uphold, obviously, the,
Yes,
you know, so that you just, is there anywhere in the affidavit that deals with that, the resource issue?
Yes, there are places where there are complaints from SASSA and DSD to explain that they haven't got the human resources, the infrastructure, etc. But what I'm dealing with at the moment is just the application stage. And what I submit is that the safeguards that we have in place at the application stage are such that struggling applicants are not left alone. They are targeted through the community outreaches, they're targeted through forums where information is spread, and then there are the other systems that I've mentioned.
Mr. Van Eerden, you're not answering my question. Does the answering affidavit give any details about resource constraints in expanding the system? Nobody is saying that online should be got rid of. The argument is it must be supplemented. And all I'm asking you is whether in the papers your client deals with the resource requirements that make it outside of its available resources to expand the system. Is there anywhere in the papers, perhaps your junior can look and you can tell us at the end?
If you will just bear with me for a moment. Okay. We'll revert on that issue. Then orders 3 and 4 are relevant to the verification stage that dealt with the test of insufficient means and what constitutes income and what constitutes financial support in the Regulation 1. The court ruled that its interpretation thereof should henceforth apply. We deal with that in our main heads in paragraph 53 to 64. Our submission is that the COVID-19 SRD is aimed to provide temporary relief for those with insufficient means on a strictly month-to-month basis. Given government's limited resources, only those who truly have insufficient means qualify for this SRD. We submit that the regulations clearly do not exclude ad hoc income or financial support. That is why all ad hoc income, such as gifts and the like, received from family members are included in income and financial support. Orders 5 and 6 are also relevant to the verification stage. Their Regulation 23C relating to the proxy means test was declared unconstitutional and invalid to the extent that they make provision for checks against databases and may indicate income or alternative financial assistance and verification of insufficient means with banks. Our main heads, paragraph 65 to 82, deal with that. The purpose of bank verification is that the first and second appellants get the most current and reliable information so that only those that qualify as of insufficient means may receive the SRD. The verification is done monthly and it remains the effective and best method to achieve government's purpose, which is to immediately reach individuals who have insufficient means and are in need of temporary assistance, i.e. for a month at a time. The reference is volume 6, page 1094, paragraph 106, 107, 108, 109, 113, and 116.
It cannot be seen on a bank account whether or not the money.
Ik kan je. Ik kan je. Talk loud.
Can't you hear?
Is die
Can you hear now? Okay. Mr. Van Eden, that type of verification also has shortcomings. For instance, where a bank account doesn't show that money is held on behalf of somebody else. Now, you've heard what I asked Mr. Marcus. Is the solution there not to allow evidence on the internal appeal?
Coming to the issue of new evidence in the appeal process, but that is certainly an instance of where one should consider new evidence. If you're dealing with 15 million applicants, there unfortunately will be cases that are so far removed that they are difficult to accommodate in a system.
I accept that. But is it a solution to an extent already that the appeal process must allow for new evidence?
Yes. I'll show you, Justice Meyer, that new evidence are in fact considered in the appeal process. The court quo, we respectfully submit, misunderstood that process. I'm going to come to the...
We don't find that in the regulations. We don't find that in the regulations.
No, but you find it in the answering affidavits. And I'll give you the references. I'll give you the references to that.
Okay,
So we are still at the, Mr. Van Eden, whilst we're still on the, what are we doing now? The income and financial support.
On 2.3c, yes, proxy means testing.
yes, and that's
In relation to orders 3 and 4.
5
Of-
and 6.
I'm busy with 5 and 6 at the moment.
Okay. So I just want to go back now then to the data verification, right? And the bank verification and the data verification. So if I receive my SRD at the post office, right? And I don't have a bank account, how does that verification process work?
I cannot explain how that specific verification process will work, but what I can explain is that the beneficiary can pick the method that he wants to receive the money in. So they are in the main two. So either goes into a bank account or it's a cash send that goes to a cell phone.
No, I understand that.
But how does SASSA verify that I'm not receiving other income if it cannot go by way of the bank verification method?
Well, if the beneficiary is not registered with the bank, they will be left only with other databases.
So
Now having the other databases, the respondents say that the appellants have, the DSD, have also confirmed that there has been exclusive errors, a lot of exclusive errors that have come to the fore. And hence, they are saying that that data verification process is not accurate at all.
The databases are as accurate as they can be. When a beneficiary is turned away because of information on a database, that reason is provided to the beneficiary. So if there's a problem with a surname, for instance, the person is told that is the reason, and that beneficiary can then attend to the rectification of the database.
I understand why you're saying it's as best as it can be. So if the data makes an error and then I do not get my grant, so be it. The answer is it's as best as it can be.
It's not that the beneficiary is then pushed away from SRD. There are many instances where the beneficiary has not updated personal information. So, for instance, on UIF it will show that the person is working, whereas the person is not working. If surnames seem to be a big problem as well. People married, adopt another surname, and then the daughter take that.
So whose
Fault is that? Isn't it the data? Isn't it the database verification and not the applicant?
It is then up to the beneficiary to attend to the rectification of the database, because that is then what will enable that beneficiary to be verified against the database.
But what if the daughter
Says I'm receiving unemployment, UIF, and in fact I'm not. So who must rectify that? The beneficiary.
It's for the beneficiary to approach the database owner and to have that rectified.
Isn't that another reason to expand the online so that those sorts of queries can be dealt with a person? Although I say that with caution because I don't know how many people readily get help from humans when they go into a government office. But let's leave that by the wayside. Put that on the side. Isn't that another reason for the need for some human face-to-face in the process? I know I'm not addressing, orders 5 and 6 go quite far. They say that the regulation is declared unconstitutional and invalid to the extent that it makes provision for checks against databases that may indicate income or alternative. It seems to order that you can no longer use that. And that 6 says to the extent that it directs grant applicants that they are assessed according to proxy means testing consisting of verification of insufficient means with banks. That's a very stark, you may not use those databases. And because of I think they go quite far, because surely there must be some means of verification. What I'm putting to you is, I'm really linking this back to the online process only route that is followed. Wouldn't some of the other complaints of the respondents, it wouldn't go far enough for them, but at least the problems with errors, and surely those could also be dealt with more properly by adding to the online only.
Justice Keatley, the ideal is, of course, to improve the online system more and more.
No, I don't know if that's the ideal. I'm simply saying to add to it with some humans, beings.
And just to add to that, a hybrid system, which you have the online system,
but as my sister has put forward, a human aspect as well.
We can't decree that.
No.
But in terms of reasonableness, anyway.
Justice Keatley, the reasonableness we submit is in the application process, where I've explained how there is an outreach
Yes, no, I understand.
to bring everybody in.
Do you then align with Mr. Marcus's submission
Yes.
that verification is necessary,
Yeah.
that bank and other database verifications is necessary, and that the fact that there are errors and so on, they can be rectified and it doesn't make those measures unreasonable? That's as I understand
As you
it.
please. I return to Orders 5 and 6, where Regulation 23C, relating to the proxy means test, was declared unconstitutional. We deal with that issue in our main heads in paragraphs 65 to 82. And I think we already made the submission that the purpose of bank verification is that DSD and SASSA get the most current and the reliable information so that only those that qualify as of insufficient means receive the SRD. We make the respectful submission that replacing the automated online verification process with a process that calls for human intervention will lead to administrative paralysis. The first and second appellants do not have the resources to process 15 million applications per month, other than through a fully automated online system. The verification methodology is reasonable and rational, and if the court acquires orders should stand, the existing payment system will come to a halt. The SRD program will have to be redesigned. It's designed on an online-only system. We rely on two authorities for this proposition. Joseph v. City of Johannesburg, 2010-4, paragraph 29. The spectre of administrative paralysis is a legitimate concern, and courts must be vigilant not to impose unduly onerous administrative burdens on the state. And Grootboom, paragraph 41, which explains that there may be more than one reasonable manner in which the state can meet its obligations. But once the methodology adopted by the state is found to be reasonable, then that requirement is met. Orders 7 and 8 declare Regulation 6C unconstitutional and invalid to the extent that it precludes unsuccessful applicants from relying on new evidence or information on appeal. We submit that those orders were based on a misconception of the appeals process. That appeals process is set out in Volume 6, page 1099, paragraph 128 and further.
And sorry?
It's Volume 6, page 1099, paragraph 128 and further. First, unsuccessful applicants are automatically advised of the reasons for rejection. That's paragraph 129. So the process is transparent. Then we submit that knowing the reason for rejection, an applicant can update his or her personal information on the relevant database with the correct information, such as the new surname or employment status. That is paragraph 131. They are allowed to update their personal details even after the rejection. And this is where the process allows for new evidence. That is paragraph 135 and 136. So these unsuccessful applicants are afforded the opportunity to remove the obstacle and the rejection of the applications. The appeal tribunal verifies and validates the information obtained of the appealer against the latest and updated information received from the database resources to determine whether the appellant did qualify. If, taking this new and accurate information into account,
what it says here is to the effect that reasons are furnished for rejection, then the applicant can have the database updated, and then the appeal tribunal will look at the updated database. The question that I posed to you was earlier on, was that why isn't new evidence allowed? Then an applicant can go and tell that tribunal this and this and this. Because not everybody will be able to go and remedy wrong databases.
To deal with an appeal process that's not automated will mean employees of SASSA will have to consider affidavits, consider bank statements, investigate that. If you have an online process where you have to, in a month, in a speedy manner, verify 15 million applications, it's just not doable.
But there are not 15 million in appeals.
Once the system is amended from online to hybrid, one doesn't know what will happen.
But even if this is now done online, not by the amendment of data. I can online object because that is not correct, and then it is up to them to check whether or not that is correct.
Yes, it is up to them, up to the unsuccessful beneficiaries.
No, then it is up to the SASSA officials. Not all the unsuccessful beneficiaries will be able to do that.
There might be